Sounds great. We're going live right now. And we are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much and good morning. This case is being called out of order since we're using a virtual platform, and it's the first case that we're hearing this morning. The number of the case is 2021-0461, Department of Children and Families versus Father and Another. I remind you all that this case is impounded, and so that we're not going to be referring to anyone by name. Let me next introduce the panel to you this morning. My name is Ariane Vuono. I'm joined today by Justice Vicki Henry and Justice Catherine Hand. As you know, Attorney Kugler, you will start off, Attorney Healy, you will start off, and you will have 15 minutes to make your argument. And as I understand it, the Attorney General's Office for the Department of Children and Families and the attorney for the child are splitting their time 8 minutes and 7 minutes. Is that right?
That's correct.
Okay. And you're probably all familiar with the virtual background, but where the seal is right now will transform itself into a clock, and so you'll have an opportunity to see how much time that you've used as your argument goes on. The other housekeeping matter is that let's hope that we don't have any technical difficulties. Having done this for over a year now, we know that upon occasion we may have them. They usually get resolved very quickly, but you should be assured that you won't lose any time of your argument if we do have any kind of difficulty, all right? Okay. With that said, then, Attorney Healy, you may begin your argument.
Thank you, Your Honor. Good morning. May it please the court. My name is Julia Healy, and I represent the appellant father in this case. The court erred in finding that the custody to the grandmother in this case, or the father's plan of custody to grandmother in this case, was not in the child's best interest, and erred in granting the department's plan of adoption by the current foster parent. Because the court did not even-handedly assess both of the plans, it considered inappropriate factors, and it did not consider all of the appropriate factors. As you know, the court must determine which plan, when there are competing plans, is in the child's best interest by using an even-handed assessment and weighing all relevant factors. The court's concern in this case was the grandmother's housing situation, financial situation, and, as the court said, DCF involvement with the child's sibling who was in grandmother's custody and had been for 5 years. And the court ignored grandmother's commitment to both of the siblings, one of whom had special needs. The court erred in relying on grandmother's housing. The grandmother had an apartment. She shared it with another family, but she had a stable apartment. It was temporary, but it was stable. She was on the wait list for subsidized housing and had been for years. She had previously owned her own home for 28 years, which is quite an accomplishment, and only lost that home because her husband unexpectedly left her and she was unable to pay the mortgage. It had nothing to do with grandmother's personal situation. The housing
counsel,
I'm sorry?
I had a couple of questions for you. So the grandmother already had 2 children that she was taking care of, right? That I think were her grandchildren. Did one of those 2 already have special needs?
Yes, Your Honor. There were 2 of this child's siblings whom the grandmother had custody of for 5 years. The grandmother also raised other children, I believe 5 children, 4 grandchildren, 2 stepchildren. I don't know if there was evidence as to anyone else having special needs, but I know that one of the siblings did have special needs.
This child also had special needs, correct? I mean, fairly significant medical and developmental issues?
The subject child had significant special needs, and the sister whom the grandmother was raising also had some special needs.
Okay. Do you know if the subject child's needs were more significant than the child the grandmother was already caring for?
I think the evidence on the subject child's special needs was more fleshed out at trial than the siblings. there was evidence that the sibling had, I hesitate to say mental health issues because I don't know that it went into that depth in the sibling, but she was troubled, I guess, as a teenager is one way to say it. There were ups and downs in her upbringing. The evidence did show that the grandmother, though, was attentive to those special needs. In particular, she filed a CRA, a child requiring assistance, with the court because when they needed to move to a shelter, the sibling did not handle it. It was hard for her. She ran away. The grandmother turned to the courts for help, which is what we ask people to do. It's why we have CRAs. She asked probation to help her find the children and to the child and to put some conditions on the child, which probation did. They found the sibling. They put a curfew on her. They put other conditions on her. Grandmother was able to move to a location that the sibling liked better. The sibling became much happier, and the grandmother requested that the CRA be dismissed. The grandmother testified that the DCF social worker told her the CRA was going to be dismissed in 2 weeks, but that worker was on vacation and it was delayed. So the grandmother at trial was under the belief that the CRA was going to be dismissed. And at trial, DCF testified that they didn't know about that. It wasn't that worker who testified. He said it wasn't his case. I think it was a gentleman. And that she was denied foster placement because she had filed the CRA.
So the department is saying that it offered the maternal grandmother monthly visits with the child, but the grandmother was not responsive for approximately 4 months and managed to only visit the child 3 times between April 2019 and January 2020. What do you say to that?
That is part of the story, Your Honor. The grandmother visited with the child beginning when the child was in the NICU, took her siblings to visit the child as early as months before the trial. There were missed visits, quote unquote, there were months without visits. Part of that, DCF rescheduled some of the visits, which I don't believe it raised in its brief. The other one was a grandmother was in a shelter for 5 months without transportation, and visits were often at the Holyoke DCF, which is not accessible to public transportation. And the grandmother had to rely on others to get there and was not able to go to some of the visits. The more or just as important thing is that the grandmother was appropriate at the visits. The visits went well. It was that DCF did not make the visits available to the grandmother by scheduling them in a place to which she didn't have access. DCF also said that the grandmother didn't bring the siblings enough to the visits, but it scheduled them during office hours when the siblings had school. So Your Honor is technically correct, but there is much more of a story behind that as to why she wasn't able to visit him.
Was there evidence that the grandmother's access to transportation had changed by the time of trial?
I apologize, Your Honor. That is not, I don't have a memory of that. I can certainly get back to you with that if you would like. I think there was definitely.
My recollection was that there wasn't, is the reason that I asked, but the subject child had a diverse collection of special needs that required access to specialty care on a variety of different topics. Is that correct?
Yeah, yes, she did. There was no evidence, Your Honor, at trial that the grandmother was unable to take the subject child to these doctor's appointments. I want to say that the grandmother had moved closer to public transportation. The shelter, she did not have public transportation, but she had moved to a different location at trial. So my understanding is that she was closer to public transportation. I don't believe she had a vehicle of her own. She also testified that she had other people who had brought her to visits in the past who could help her, bring her to these medical appointments. But again, just as importantly, there was no evidence that had she had custody of this child, she would not have been able to bring her to a visit, that she wouldn't have been able to, obtain a vehicle or obtain help with friends. That's a big leap. We don't know that. She wouldn't be able to do that.
Historically, though, that had been a spotty proposition for her, correct?
I know when she was at the shelter, it was hard for her to get to visits, but there was no testimony with the sibling on whom she had the CRA, that there was no evidence that she could not get to court for that sibling. So, and that sibling had other needs. So there was no evidence of a long-standing inability of the grandmother to get where she needed to go. So I think DCF took a leap in its brief and said, well, she won't be able to get to these doctor's appointments. We don't know that. And again, poverty, and this is another one of my arguments, poverty is an inapplicable factor upon which the trial judge weighed in not choosing the father's plan. Poverty, housing is poverty. Having your own car is poverty. It is inappropriate for the judge to consider the foster parent's income over the grandmother's income. There is nothing to say this grandmother could not have found a way to get to these appointments. She didn't have to. She didn't have custody of the child, so we don't know.
So counsel, I'm sympathetic to your argument that the siblings might have had school during the appointments that DCF offered for visitation, but you argue that that the finding that there was no bond between the child and the siblings that the grandmother was already caring for was clearly erroneous. But what evidence is in the record is there that there was a bond?
That the grandmother said that she took the siblings to visits as often as she could, I believe was the quote. And they had been to see her as recently as I believe the month or months before trial. In addition, Your Honor, the foster parent was supportive of sibling visitation. And one would have to assume that she would not have done that had there not been a bond there. And DCF's own adoption plan supported sibling visitation. So there is evidence that there was a bond.
Child argues that the father did not complete any tasks on his service plan. What do you say to that?
To that, Your Honor, I say that as you know, DCF must use reasonable efforts to reunite the family, including providing services to strengthen family life. Giving a list of services under adoption of Elaine is not enough. That is not providing services, ever. In this particular case, you have a client with undiagnosed mental health issues, undiagnosed, untreated schizophrenia and depression, homelessness, and substance abuse. DCF knew that giving him a list of services, which is exactly what they did, there's no evidence that DCF provided him anything, including the services that he tried. There's no evidence that DCF helped him get those. Giving this particular client a list of services clearly wasn't enough. And if DCF didn't know that simply by knowing that, it was clear by the fact that my client tried to get himself into treatment and it didn't work because we don't know if it was the right treatment. We don't know how much support he had because DCF did nothing to support him. My client had 3 Section 35s. 35s are when you're in crisis, when you or someone you love or someone who knows you is screaming, this person needs help. DCF knew that he had been committed 3 times and still did not say, let me look into the proper mental health treatment for you, proper substance abuse, try dual diagnosis, whatever it is. DCF is the one with the money and the mandate and the manpower to provide these services, most importantly, the legal mandate, and their own mandate makes them provide it.
So could I interrupt you just to ask, understanding your argument that DCF had the obligation to provide them, was the issue of reasonable efforts raised at any point before appeal?
Thank you for asking that, Your Honor. I would like to be clear on what our reasonable efforts argument is. We are not raising the issue of reasonable efforts for the first time on appeal. We are not allowed to do that. We would not do that. We are presenting an argument based on the trial court's findings of facts and conclusions of law, both on the findings and conclusions the court made regarding reasonable efforts and the lack of the court's finding that DCF made reasonable efforts to reunify this child. The only way to attack those findings and conclusions is through an appellate brief. Clearly at trial, we don't know what the judge is going to find or not find. So we have every right, I believe, on appeal to argue the court's findings and conclusions, which is what we are doing.
So your argument is that the court, I think the court varied some language and that it did not specifically find that the department had made reasonable efforts. Is that right?
The court absolutely did not find that. The court found that DCF attempted to remain in contact with my client, that DCF attempted to engage my client in services. The court specifically found that it was impracticable for DCF to assist my client by making referrals in custody, which I would simply like to point out to the panel that DCF's own regulation 1.10 says that DCF must make all reasonable efforts to work with an incarcerated client, including regular visitation, case conferencing, and other consultations. So that finding is an error, and the judge erred in making it. And the court never found that the court made, that DCF made reasonable efforts. As the court knows from the recent SJC case of care and protection of Rashida, the SJC recently confirmed the importance of DCFs making reasonable efforts, said they don't have discretion to make them or not, they have to make them, that reasonable efforts include appropriate services designed to improve a parent's capacity to provide a safe home for the child. And most importantly, I believe in this case, reasonable efforts are a comprehensive review of the entirety of DCF's action in each case.
Counsel, though, did the father complete any of the tasks on his service list?
I believe he tried to engage in substance abuse counseling and was unable to complete it. So what DCF did, Your Honor, was they gave the client a list of services instead of providing the services, waited for my client to fail, and then blamed my client for his failure. As I said, my client has undiagnosed mental health, substance abuse, homelessness. One would assume no access to, not easy access to the internet to look these programs up, not the mental capacity to understand which programs are good for him, would take his insurance. DCF basically set up my client by saying, do something we know you can't do, and we're going to hold it against you when you don't do it. If there are no further questions, I see my time is coming to an end. I will rest on my brief. Thank you.
Thank you very much. I'm just going to check with the panel. I don't see that either one of them have any further questions. Thank you very much, Attorney.
Thank you, Your Honor.
We'll go now to Attorney. Now I want to say, is it Salcedo or Salcido? How do you pronounce your name? Okay.
Thank you, Your Honor. May it please the court, Richard Salcedo for the Department of Children and Families. And as court mentioned, I'll be splitting my time with counsel for the child this morning. The department is asking this court to affirm the trial court's decision finding father unfit and terminating his parental rights. Careful review of the trial court's findings show that close attention was paid to the evidence, and those findings taken together clearly and convincingly support the trial court's conclusions. Subject child in this case has been in the department's custody since her birth in October of 2017. She's been in the same pre-adoptive placement since November of 2018. At her birth, she tested positive for cocaine, heroin, methadone, and marijuana, and spent 17 days in the neonatal intensive care unit. As the court mentioned earlier, also the record indicates that she has significant.
The father argues that the department basically gave him this list of services, but didn't actually give him any services and set him up to fail. You just heard her argument. So what do you say to that?
I would say, Your Honor, that the provision of or direct referral of services in this case was significantly impacted by the fact that father was incarcerated out of state at the outset of this case. And after his release, he was in Florida. After his release, he was whereabouts unknown. The court found that the department made significant efforts to locate father and engage him in services, but that he failed to follow through. There were services available to him. He was, as the court found, was enrolled in a program in 2018 for mental health and substance abuse treatment, but that he quit the program after a couple of days or a couple of meetings because he said he did not like it. He testified to that. Father has simply shown little interest or effort in engaging in the services that the department outlined in two action plans that the department developed for him.
Did the court fail to use the language we require? Did the court actually find that the department made reasonable efforts to unify?
I believe they did, Your Honor.
That is, I'm sorry.
I believe, yes, Your Honor, they did. The court did. If you look at record appendix at 144, the court does include a whole entire section with the heading reasonable efforts, outlining what the department, the various action plans the department developed for both mother and father in this case. I think what the court was noting was that the department had the challenge of providing services in this particular case because of father's lack of contact with the department, the fact that he was incarcerated or in custody or committed to treatment for much of the case, which is different than some of the cases we see in these matters.
So the father argues that the finding that the children the grandmother was caring for were not bonded to the child, that's clearly erroneous. What do you say to that?
I would say that there is little evidence that there is a bond between these siblings. They have never lived in the same household. As I mentioned, the subject child has been in the department's custody since birth and has resided in foster care since and in the same placement since November of 2018. The two siblings who reside with mother have resided in various placements, have had little contact and little connection with the subject child. There were only a few visits, according to the record, in this matter between them. As a result of the child being exposed at birth to various substances, she has received and has significant global developmental delays. She's received various services over time, including occupational therapy, physical therapy, and early intervention services. And she's been seen regularly by an ophthalmologist, a neurologist, and the Perkins School for the Blind. The court found that since being placed in her current pre-adoptive home, the family has met her significant needs, and she is thriving in their care. It's the department's plan for this child to be adopted by that family. The court also properly assessed father's proposed alternative plan to have the child placed in the care or in the custody of maternal grandmother. In assessing that plan, the court considered several appropriate factors, including maternal grandmother's long history with the department, which in fact dates back to the time when she parented the mother of the subject child in this case. But more recently, with regard to the older granddaughter who was residing with her, who at the time of trial was approximately 16 years old. The record indicates that she's had many difficulties dealing or managing with that child's serious behavioral issues. And those difficulties are detailed in the court's findings at page 141, 143.
Is there any issue though with what you can have an amazing parent who for whatever reason has a child that has a lot of difficulties. Is there an attribution to the grandmother for some of the difficulties that the older child is having?
I'm sorry, could you repeat that question, Your Honor?
You can have the father's counsel points out we want people to turn to help, and the issue is then using that effort to get help for the older child against them. You can have a parent, or in this case a grandparent, who's amazing, but a child just has difficulties. So I'm trying to understand how we draw that line. Did this grandmother have particular deficiencies that resulted in that open matter, or were the challenges attributable to the older child?
I think that if what the record shows is that that the maternal grandmother failed to meet the needs of this particular sort of minimal needs in particular. There is evidence in the record that while residing with maternal grandmother, that she was exhibiting serious issues, including suicidal, homicidal ideation. And during that particular time, the record shows that the child was not taking prescribed medications while in the care of the maternal grandmother and was not receiving services consistently. The record also indicates that this particular child has a history of running away, and that recently she became pregnant while she was on the run and was living with maternal grandmother and was not attending school. And the court, or the record indicates that she was not or had not looked into or developed to work with the school to develop an alternative educational plan for the child.
Yeah, I see that your time is up. I'm just going to check with Justice Henry to see if she has any follow-up questions. I see that she does not. So thank you very much for your argument.
Thank you, Your Honor.
Send a brief, and now we'll hear from Attorney Kruger.
Good morning, Your Honors. Yvette Kruger here on behalf of the child in this matter. I'd like to thank the court and counsel for allowing this Zoom argument today for me. Well, everyone has hit on many of the important major points. I would like to state on behalf of the child that the pre-adoptive parents have provided and will provide the child permanence, stability, and nurture that maternal grandmother cannot offer and cannot provide. Earlier, one of your honors asked, are one of the needs greater than the other of between the older child, Tatiana, that the maternal grandmother is taking care of? They're different. And I would suggest that the older child who's now pregnant, who was pregnant at trial, her needs are, her behavioral challenges are severe and have had been since she's 7 years old for a history of 10 years. She'd been in and out of maternal grandmother's home. Maternal grandmother was supportive for neglect earlier on. And when that child's behaviors were most violent, DCF found that maternal grandmother was not providing the child immunizations at the time. Further, with regard to father's argument that there was no evidence that maternal grandmother could not get the child to her various medical appointments around the state, maternal grandmother testified that she was unable to, among the reasons she was unable to visit was because she lacked her own or public transportation from one of the shelters that she was in for many months. No fault of her own, but the child's best interests are paramount, which is well settled. And this child has services of early intervention, occupational therapy, physical therapy. She sees a podiatrist to work on her muscle development and proper walking development. And the pre-adoptive parents have provided her a loving home, met all of her significant needs, and it's uncontested that she is thriving in their home. On the other hand, maternal grandmother failed to establish any relationship with her granddaughter. She waited 1.5 years before, perhaps she was in the NICU, but it was 1.5 years before she had a DCF visit. And after that one visit, she disappeared and was unresponsive to DCF for 4 months, and then had 2 visits under the wire, shall we say, just before trial. I believe maybe 1 or 2 of those visits, I presume a 1-hour visit, was with the 2 children in her care. That is not enough time for any bond to occur. So I would also add that maternal grandmother's instability, she was in 2 different shelters in 2 very different parts of the state over the year prior to trial, through no fault of her own, but these are the facts. And she filed a child requesting assistance only months before trial, which was ongoing, and the court discredited maternal grandmother's testimony that the older child's running away and behavioral problems had been solved by relocation to another place that suited the child's likes better. Also, I'd like to note that the judge twice noted that maternal grandmother testified she was surprised to learn, was unaware that mother was using heroin 3 weeks before trial. She also allowed mother in her home the day before she testified, as well as father within the months before trial. This is counter to the child's best interests, who needs and deserves permanence and stability. So if your honors have any further questions.
I see none. I want to thank, on behalf of the panel, all three of you for your briefs and for your arguments today. We know these cases are always very difficult cases, and so you can be assured that we will give it our utmost attention. We'll take the case under advisement, and we'll get back to you as soon as we can. Okay.